Thank you for joining us for this month's installment of our monthly webinar series on timely education habits. We especially appreciate you joining us during this busy back-to-school time.
I'm sorry for the interruption. This is Toby with Ready Talk. You're coming in very, very low.
Good morning and welcome, and thank you for joining us for this month's installment of our monthly webinar series. We especially appreciate you joining us during this busy back-to-school time. I am Amy Dickerson, and this morning I am joined by my colleagues Scott Metcalf, Mary Louise, and John Spinney, who will provide an overview of new laws and legislation affecting schools. For those of you who are not familiar with Franczek, we are a law firm of approximately 40 attorneys who focus on education, labor and employment, employee benefits, and immigration law. Before we get started, there are just a few housekeeping items to address. First, right under the presentation slide, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Everyone logged into today's program will receive an email that includes a link to the recording of the webinar as well as the presentation. I will now turn it over to Scott, Mary, and John.
Sounds like we may have some difficulty with our microphones based on some of the questions that we're getting online, but hopefully everyone will be able to hear us going forward. For about the past 10 years, Franczek has been doing an annual summary of new legislation affecting school districts, and our 2018 summary will be coming out before the end of August. We're currently waiting to see what the governor does regarding vetoes. Over the past 4 days, the governor has vetoed about 8 bills that would have affected school districts. And once he's done and taken action on all of the bills on his desk, we'll be sending out our summary to everyone on our FR Alert distribution list, as well as posting this information on our Twitter accounts and our LinkedIn accounts. Now, this year we've seen more vetoes than we've seen in past years. The governor includes a veto message explaining his reasons for each veto. And these bills that were vetoed and the governor's reasons for vetoing them are worth discussing because they shed some light on the future of the state's education policies. So the first bill that the governor vetoed recently was House Bill 768. This bill would have removed the power of the Charter School Commission to reverse the school board's decision to deny, revoke, or not renew a charter, among other things. That means that a circuit court would then have been the only avenue to appeal the school board's decision. The governor's veto message stated that the Charter School Commission is more well-equipped to handle these appeals and went on to say that the commission should continue to be empowered to ensure that all Illinois children have access to a high-quality education. Another bill that was vetoed recently was Senate Bill 2572. This bill would have changed the physical education requirement from 3 days per week to 150 minutes per week. The governor's veto message was 4 points. He basically stated, first, that these decisions are best made at the local level. Second, a minute-based mandate may result in the reinstatement of the daily physical education requirement that was just removed last year with the education funding reform legislation. And third, he stated the bill didn't account for weeks where students are not in attendance for 5 days, and finally stated that the minute-based requirement would deprioritize other subjects. The governor also vetoed House Bill 4284. This bill would have required 3 members of the Illinois State Board of Education to represent the educator community. The governor's veto message stated that this bill would erode his executive branch appointment power, and it would put Illinois at odds with national best practices because only 5 out of the 38 states where the governor appoints state board members mandate what the board's composition is going to look like. The governor also vetoed House Bill 1262. This bill would have required that mandate request waivers under Article 17 of the School Code be submitted to the General Assembly for consideration. The governor's veto message stated that this bill would have undermined the streamlined mandate waiver process implemented last year, again as part of the education funding reform legislation. In terms of curriculum, the governor recently vetoed House Bill 3792. This bill would have required the development of a curriculum beginning in the 6th grade on the importance of developing and applying a work ethic in a variety of contexts, including instruction in professionalism, punctuality, and attire. The governor's message stated, and I quote, "It's not the role of the legislature to dictate to schools how and when this skill should be taught. Schools and teachers deserve the freedom to design their own curriculum." The governor also vetoed House Bill 5481. This bill would have required school boards to report the following information on class sizes to ISB: the total number of teachers actively employed, pupil-teacher ratios, the number of class instructors by grade level and subject, for teachers assigned to multiple class sections, the class of each section and caseload, and for teachers assigned to a single class, the class size listed by teacher. The bill further provided that the goal of the General Assembly would be to make adequate provisions to ensure that by the 2021 school year, class sizes would not exceed specified limits. The governor's veto message stated that the bill is redundant since this information is already published in school reports. He went on to add that since the current class size averages in Illinois do not differ vastly from the goals set forth in the legislation, this bill would be yet another unnecessary directive from the General Assembly. The governor also vetoed Senate Bill 2345. This bill would have required ISB's school report cards to include whether the school participated in the Illinois Youth Survey, which is designed to gather information about the health and social indicators of students in grades 8, 10, and 12. The governor's message stated that mere disclosure of a school's participation in the survey would not reveal any substantive findings, and this mandate would cause unnecessary confusion without providing any useful information. Finally, House Bill 4657 was vetoed as well. This bill would have created a task force to help develop curriculum guidelines and best practices on emotional intelligence and social and emotional learning. The governor's veto message stated that creating a task force without any substantive directives as to how to address the issue would only add to government waste. These bills will now be eligible for a veto override during the General Assembly's fall veto session. The veto session is scheduled for November 13th through 15th and November 27th through 29th. A 3/5 vote in both houses is required to override the governor's veto, so we'll see how it plays out in November with these bills. But both the bills that were vetoed and the reasons for the veto, I think, shed some light on the governor's thinking going forward. But I think it's time that we turn over to some bills that were actually signed by the governor, and for that, I'm going to turn it over to Mary DeWeese.
The first new piece of legislation that we're going to talk about today is known as Ashley's Law. It was Public Act 100-0660. And under Ashley's Law, which is effective August 1st, meaning 3 weeks ago, it went into effect, students with medical marijuana cards may be administered cannabis products at school. The school code now allows qualifying students to be given medical cannabis-infused products at school or on the school bus. A medical cannabis-infused product is an oil, an ointment, a food, or other product that contains usable cannabis that is not smoked. A parent, a guardian, or a designated registered caregiver must be the one to administer the cannabis-infused product to the students, and they must remove the product from school premises after administering it. This law only applies to students who are registered qualifying patients under the Compassionate Use of Medical Cannabis Pilot Program, which means that they have in layman's terms, a medical marijuana card. And both the student and the designated caregiver must have a registry identification card. Students have to have been diagnosed with a qualifying debilitating medical condition by a doctor in order to have this medical marijuana card. And a designated caregiver has to be over the age of 21 and can only be responsible for giving the medical marijuana product to one individual. No, this Ashley's Law does not require school employees to administer the medical cannabis products. It also states that schools do not have to allow the use of the medical marijuana products at school if it would, 1, disrupt the school's educational environment, 2, expose as a result of doing so. This law applies to school districts, public schools, charter schools, and must now adopt policies to implement Ashley's Law.
So that brings us to the Government Severance Pay Act. Now, this law, which goes into effect at the start of next calendar year, so January 1st, 2019, applies to units of local government. So we have school districts. We also have public universities that this will cover. And it applies to severance pay provisions within contract agreements. So this act requires that agreements limit severance pay to an amount not greater than 20 weeks of compensation. The act also prohibits severance pay when an employee is fired for misconduct. And the act actually defines misconduct. There are 6 different acts that can be misconduct. First, conduct demonstrating disregard of an employer's interest. So this could be willfully damaging an employer's property or theft. Second, we have carelessness or negligence, but to a degree that shows culpability or a wrongful intent on behalf of the employee. Chronic absenteeism or tardiness is also misconduct when it's knowingly done in violation of a known policy. Willful and deliberate violations of a standard of the state, which could then cause the employer to be sanctioned, is also misconduct. And a violation of an employer's then that's not misconduct. If the rule itself is unlawful, also not misconduct. And if the rule is not fairly or consistently enforced, then also not misconduct, and a severance package may be given. Finally, there's a catch-all provision for other illegalities, which might be criminal assault or battery or abuse or neglect. And that moves us into a broader topic of substitute teachers. Now, here we actually have 3 different bills that have come out that impact this topic. I will note, though, that the first 2, HB 4706 and HB 4742, have not yet been signed into law. Only the third, PA 1000596, has been signed and enacted. So we'll keep an eye on the first 2 and let you know what happens there. But with HB 4706, the first one on the list, school boards are now allowed to require that substitute teachers provide evidence of physical fitness to perform their assigned duties. School boards must now require that substitute teachers provide evidence of freedom from communicable diseases. And this may require that the substitute teacher obtain a physical examination by a healthcare provider. In such a situation where a substitute teacher does have to get a physical examination, that cost is on the substitute teacher under this law. But the bill also does recognize that school boards may, from time to time, require examinations of any substitute teachers, not just new substitute teachers, and that cost must be borne by the district itself. Second, HB 4702 is not, as of right now, something that applies directly to school districts, because this bill, if signed, would first require ISB to implement a program through which eligible school districts can supplement their substitute teacher recruitment with the use of a recruiting firm. ISB must implement this program if this bill is signed by January 1st, 2019. And even then, the school district has to qualify in order to use the recruiting firm. To qualify for the program, a school district must demonstrate to ISB that because of a severity of a substitute teacher shortage, the school district is unable to find an adequate amount of substitute or retired teachers and has exhausted all other efforts. In that case, they can go to a recruiting firm to find those employees. And finally here, the only law on this page that has actually been signed into law as of this point, PA 100-0596. And this law changes several things. First, the Act increases the number of days that a retired teacher may substitute teach without impacting their retirement. So the number's been increased from 100 days or 500 hours to 120 days or 600 hours. But caveat, the teacher cannot spend more than 100 paid days in the same classroom. Also, notably under this Act, time is reduced back to 100 days or 500 hours starting July 1st, 2020. So this is just a temporary increase. Second, this Act establishes that beginning July 1st, 2018 and until June 30th, 2023, ISB can now issue a short-term substitute teaching license. The license can be issued to any qualified applicant for substitute teaching in all grades of public school. Those licenses will not be eligible for endorsements, and applicants must hold at least an associate's degree or have completed at least 60 hours from an accredited institution. So an individual who holds one of these short-term substitute teaching licenses can teach up to 5 consecutive days per teacher, per licensed teacher. And if more than 5 days is needed, then an individual with a substitute teaching license cannot be used for that substitute role. And finally, each school board must now develop a short-term substitute teacher training program for individuals holding a short-term substitute teaching license. Now, the Act does say that ISB may develop a model program under this Act, so we'll wait and see if that happens, and then obviously that would be something that we would roll out to you.
Another new law is Public Act 100-0984, which is SRO Training. Under this law, the Illinois Law Enforcement Training Standards Board is charged with developing an SRO course within the next year that consists of at least 40 hours of training for school resource officers. All school resource officers will have to complete this training within 1 year of assignment to a school unless they're eligible for a waiver from the Illinois Law Enforcement Training Standards Board, and their waiver will be based on their prior training and prior experience. While the Training Standards Board has to develop this training course within the next year, it's not going to be until 2021 that schools will begin receiving these certificates for their SROs, meaning the Law Enforcement Training Standards Board is going to have to develop this training program, and then by 2021, it'll be required that all SROs take this training course and get either a certificate or a waiver, and that school districts will be presented with these certificates by beginning in 2021.
So here again, we have a slide that touches on multiple topics that are on a same theme, which is medication in school. First, we have PA 100-0799, which touches on epinephrine use in schools. This Act didn't really do too much other than amend a definition within the self-administration and self-carry law. And it clarifies that an epinephrine injector may either be an auto-injector or a pre-filled syringe. That either of those two options are fine under the Self-Carry and Self-Administration Act. Second, we have PA 100-0726, which touches on asthma. And this shouldn't be too unfamiliar to those of you who are familiar with the Self-Carry and Self-Administration Act, and basically just extends that to asthma medication as well. So under this Act, school districts are permitted to authorize a school nurse or trained personnel to provide undesignated asthma medication to students for self-administration. Now that could be a nebulizer or that could be an inhaler, but again, asthma medication. The school nurse or trained personnel may also provide undesignated asthma medication to any personnel authorized under a student's health care or asthma action plan, a 504, or an IEP to administer asthma medication to that student that meets the student's prescription that the school has on file. These personnel may also administer undesignated asthma medication that meets the prescription on file to a student who has an individual health care plan. The school nurse or trained personnel may also administer undesignated asthma medication to any individual that the school nurse or trained personnel believes in good faith is suffering from respiratory distress while in school or at a school-sponsored activity or under the supervision of school personnel. Now, within 24 hours after administering undesignated asthma medication, a school must notify the student parent or guardian or the emergency contact and the physician who provided the standing protocol and the undesignated asthma medication that the medication has been used. Within 3 days of the use, a school district needs to let ISB know that the undesignated asthma medication was used. Finally, this act requires that training be completed annually in recognizing and responding to respiratory distress, and it does outline the requirements of such training.
We have another law here, PA 100-0768, and this is on using student growth data and evaluations. The districts have been required to have joint committees on the use of student growth data in teacher performance evaluations prior to this year. As a reminder, this joint committee is supposed to be composed of persons selected, of equal representation of persons selected by the district and selected by the teachers or their union. What PA 100-0768 did was that it specified that the joint committee has to meet at least once annually to assess and review the effectiveness of the district's evaluation plan. And the new law also exempts meetings of these joint committees from the Open Meetings Act. And we also wanted to touch on a law that was actually passed last year but became effective over the summer that we've been getting a lot of questions on, and this is the Accelerated Placement Act. Under the Accelerated Placement Act, school districts were to have adopted an accelerated placement policy by July 1st of 2018. This accelerated placement policy must allow grade acceleration, meaning having a student skip a grade, move up from one grade to the next before his or her peers. Subject acceleration, meaning that they skip ahead in a single subject. And early entrance to kindergarten and first grade. And this, under the Accelerated Placement Act, these types of acceleration have to be open to all students of high ability and who may benefit. The district's accelerated placement policy has to include an assessment process with multiple referrers, which means that a student's parents can refer him or her to be evaluated for accelerated placement, as could the student's doctor or other trained personnel with knowledge on the student. And they have to use multiple valid, reliable indicators in assessing the student for accelerated placement. And as I said, districts were to have adopted an accelerated placement policy by July 1st of this summer, and that policy is different than if your district has a gifted and talented policy. Accelerated placement is different than gifted and talented. For our districts who use PRESS, PRESS has come out with an accelerated placement policy, but Franczek is happy to review your policies with you to make sure they're compliant with the accelerated placement law.
Okay, so thank you again for joining us this morning. We see that we may have one question that has come in, just seeking to clarify whether or not grade acceleration means that a student could test out of certain types of course content. Mary, is that something that you want to clarify?
Our current understanding of grade acceleration means that a student who should be age-wise in third grade with his or her peers accelerates to fourth grade, or when his or her peers go to fourth grade, he skips ahead to fifth grade. Versus subject acceleration could mean that a student were to test out of certain course, a math class, for example, if the student quote-unquote tests out of 8th grade math to go to 9th grade math instead. That would be single subject acceleration. And I see another question about the press policy. So there is some confusion under the early entrance provisions of the accelerated placement policy. Prior to this Accelerated Placement Act, there remains a school code provision that allows for early entrance for a very specific subset of students. They are students who will turn 6 by December 30th, who attended a private preschool and the same private school for kindergarten, and were taught by a licensed, an ISB certified teacher in that kindergarten. Those students who demonstrate readiness have to be admitted, or must be allowed quote unquote early entrance to first grade despite not meeting the September age cutoff. There is some debate back and forth as to whether or not the Accelerated Placement Act creates a conflict with this provision. However, we recommend, and I believe that press recommends, that the early entrance policy, the school's early entrance policy both allow for early entrance through accelerated placement and through this, what I would call the private kindergarten provision for early entrance.
We also got a question about what and to the school, and then the school can keep that then on its premises in case it ever needs to use it for a student.
Okay, well, thank you again for joining us today. Where we will discuss homeless students, a topic on which we have received a number of questions recently. You will receive an email today with a link to the program's recording and presentation, as well as a link to register for our upcoming webinar. And to the extent that any additional questions come in right at the end of the hour here, we'll seek to follow up with you as well. Have a great afternoon.